Hello, my name is Bradley Supernaw, and I am an attorney in Nebraska. This video is going to be on the process of getting a divorce in Nebraska. The laws vary from state to state, so if you don't live in Nebraska and you're in the process of a divorce or thinking about a divorce, the process might be different in your state, and it'd be a good idea to consult with an attorney licensed in your state to find out. As always, this video is intended for informational purposes only and is not intended as legal advice. Every case is going to be a little bit different depending on the specific facts of the case. Before we get into the process, there are a couple of requirements that you should be aware of. First, Nebraska is a no-fault divorce state. This shouldn't be confused with no-fault insurance. That's a completely different area of law. When someone says no-fault divorce, what they're saying is that the spouse seeking the divorce does not have to prove that the other spouse did anything wrong or is at fault for the divorce. Nebraska is what you might call a true no-fault divorce state. There are some other states that are similar. In Nebraska, the only grounds for divorce is that the marriage is irretrievably broken. If the other spouse did something like committing adultery or something like that, that is not relevant to a divorce in Nebraska. When this video was recorded, every state in the United States allowed for no-fault divorce. I used to practice in New York. I didn't practice family law when I practiced in New York. But while I was living there, the state legislature passed a no-fault divorce law. And as I recall from the news articles about it, at that time, New York was the last state that did not have no-fault divorce. So after that law passed, every state now allows for no-fault divorce. Second, Nebraska, like many states, maybe all states, I don't know about this, but Nebraska does have a residency requirement. In Nebraska, one of the spouses has to live in the state for at least a year before filing for a divorce. There is an exception. If the marriage occurred in Nebraska, if the marriage occurred less than a year ago, and if one of the spouses lived in Nebraska for the duration of the marriage, you can still file for a divorce in Nebraska even though you haven't lived in Nebraska for a full year, but you have to meet those three requirements. So divorce in Nebraska starts with the filing of a complaint for dissolution. Sometimes this is called a petition for dissolution. Since Nebraska is a no-fault state, the complaints from one divorce to the other are generally pretty similar. They will lay out some of the basics of your marriage. You know, where do you live? Where does the spouse live? Are there any children of the marriage? When were you married? Things like that. The complaint will also state that the marriage is irretrievably broken with no likelihood that it can be preserved. That has to be alleged in the complaint since that is the grounds for the divorce. The complaint will also list the relief that you're seeking. This can be things like, obviously you're going to be seeking a dissolution of the marriage, so that's going to be one thing that's going to be listed. It will ask for the marital property and marital debts to be equitably divided. It may ask for child custody and child support to be determined. It might ask for alimony or spousal support, although that's not too common in Nebraska. And it will sometimes ask for the wife's former name to be restored if that's something that she wants. Once the complaint is filed, the other spouse, who is called the defendant, will need to be served with the complaint. This can be done either by a voluntary appearance. The filing spouse's attorney will mail a copy of the complaint with a form called the voluntary appearance to the defendant, and the defendant will sign the voluntary appearance and return it to the filing spouse's attorney, who will then file it with the court. If the defendant spouse does not return the voluntary appearance, they can be served by certified mail. They can be served by the sheriff of the county where they live. Those are the most common. If they can't be located or if they can't be served by these other methods, then you can request an order from the court to do another type of service. For example, I was able, in one case, when the defendant's spouse was not able to be served, I was able to get the court to allow me to serve the other spouse by email. And I have heard situations where sometimes spouses who can't be served are served by Facebook Messenger, or a common way to serve a spouse that can't be otherwise served is through publication. All of these other ways are called alternative service, but that's not terribly uncommon. Usually it's going to be either the voluntary appearance, certified mail, or the sheriff in the county where the spouse lives. Sheriff's offices are pretty good about finding people and getting them served. Once the defendant's spouse is served, or once the voluntary appearance is filed, the spouse will have 30 days to answer the complaint. In their answer, a lot of times they will do a counterclaim, and in that they will list what they want out of the divorce, which a lot of times will say the same thing. But if, for example, the spouse that filed the original complaint asked for sole custody of the children, they might ask for sole custody for themselves, or for joint custody, or some other type of custody. If the defendant's spouse does not file an answer within 30 days, then the court can proceed to a final hearing. However, there is a 60-day period before the court can enter a decree of dissolution. So even though the defendant's spouse only has 30 days to file an answer, realistically the court's not going to hold the final hearing before the 60 days is up, even if the defendant's spouse does not answer. In some cases, the parties may ask for the court to issue a temporary order. The temporary order deals with things while the case is ongoing. So it can deal with issues such as who stays in the marital home, what is the custody and parenting time arrangement for the children. It can ask if there's concern that one spouse may spend the marital funds on frivolous things or try to dissipate the marital funds or marital property. It can ask for what's called an anti-hypothecation order, which basically means you can't spend marital funds or assets on things except for what you need for daily living, or if you're operating a business, for what you need to operate the business. If the circumstances change during the course of the divorce, the temporary order can be modified to account for the changes in circumstances. If there is a temporary order in your case, it's very important to follow the temporary order. If you don't follow the temporary order, you could be held in contempt. After the answer is filed, the case moves into what's called the discovery phase. Discovery is just an exchange of information and documents between the parties. So, for example, one spouse might not know all of the bank accounts or other assets, investment accounts that the other spouse has. So during discovery, that's when that information would be disclosed. Also during discovery, the parties will negotiate and try to come to an agreement on all of the issues that are raised in the divorce, in particular property division, and if there are children, custody, parenting time, and child support. If child custody is an issue and the parties are not able to come to an agreement, in Nebraska the parties will be required to try to mediate the custody issues. Mediation involves a neutral third party sitting down with the parents, trying to help them come to an agreement on the child custody issues. The neutral third party often is an attorney, but not always. The mediator is not there to give legal advice to either party, and the mediator is not there to make any decisions. They are just there to help facilitate the communication between the parties. Nebraska has some really good mediators, can be very helpful at helping parents come to an agreement on custody and visitation issues. If the parties are able to come to an agreement on all the issues, including child custody, visitation, child support, property division, debt division, then their attorneys can draw up a proposed decree, property settlement agreement, parenting plan, and any other documents that might be needed to complete the divorce. Everybody signs the documents, they're presented to the judge. Usually, unless something looks really out of whack, the judge will sign off on it and sign the decree for dissolution. If the parties cannot come to an agreement on all of the issues, then they will need to go to trial. In Nebraska family court, the trial is called the final hearing. At the final hearing, each side will have the opportunity to present testimony and evidence to support their arguments, to support their position, to try to convince the judge why the judge should agree with them rather than the other spouse. And testimony, almost always will be of the two spouses, of course, but testimony can also come from other family members or friends, depending on if they have information that would be relevant for the judge to make a decision. Testimony can come from, for example, an expert, somebody who maybe did an evaluation on a privately owned business, for example, or somebody who did an evaluation of the marital home. Documentary support can be anything from, it could be, if custody is an issue, it can be school records sometimes come into play. On the financial side, banking records, again, an appraisal or evaluation of the marital home, investment records, things like that. As I mentioned earlier, in Nebraska, the final hearing can't happen less than 60 days after the defendant spouse is served or after the defendant spouse files a voluntary appearance, or a voluntary appearance is filed on behalf of the defendant spouse. The divorce does not become final until 30 days after the decree is signed. Unless one of the spouses dies, then it becomes final on the day it's signed. If you get a divorce in Nebraska hoping to get remarried right away, bad news, you're going to have to wait at least 6 months. The divorce doesn't become final for the purposes of remarriage until 6 months after the decree has been signed. So once the decree is signed and those waiting periods are over, you're divorced. That's it. So as I mentioned at the beginning of this video, family law varies from state to state. So that's a basic description of the process in Nebraska. If you're not in Nebraska, or if you're not getting a divorce in Nebraska, it may be different in your state. So I would recommend that you speak to an attorney licensed in your state to find out what the process is in your state. If you are in Nebraska and you are either in a divorce or thinking about a divorce and you have any questions, I would encourage you to reach out to a family law attorney in Nebraska. My contact information is going to pop up at the end of this video, and I will also put it in the description at the bottom of this video. I hope you found this video interesting. I hope you found it informative, and thank you for watching. Until next time.